There was a very significant decision by the U.S. Supreme Court on the issue of personal jurisdiction over corporations. The case involved Daimler-Benz, and the court found that there was no jurisdiction over Daimler in California, notwithstanding that it had a subsidiary that had billions of dollars of business in California. And just to be clear, what the Supreme Court held was that for a corporation, the only place it could be sued would be its state of incorporation or where its principal place of business was, or potentially in other states if they had a really significant relationship with that state. So that's one of the things that remains is what other states can a corporation be sued in other than its place of incorporation and its principal place of business. What you have is the opportunity to get cases dismissed if you're sued, if your client's sued in a jurisdiction that's not its principal place of business or place of incorporation. The advice, of course, is to determine whether the company prefers to be sued somewhere else, because typically, if you're not able to be sued, let's say in New York, you can be sued in Delaware if that's your place of incorporation, or if your principal place of business is in California, you could be sued there. So sometimes strategically you might decide it's not worth making the motion and you'll voluntarily submit to the jurisdiction. So that's some of the strategic issues that you have to consider is, do you want to make the motion? Do you want to effectively compel the plaintiff to sue you in a different jurisdiction, and where would you most prefer to be sued? I think there are going to be some changes because states are going to be concerned that they have businesses operating in their state, very significant business, that cannot be sued in that state on a general basis. And so I think you're going to start to see states make more of an effort to compel companies that are operating in their state in a significant way to voluntarily submit to jurisdiction.